ARM's motion. Since last spring, we've been conducting discovery, and there's one remaining document issue. Glencore, the company that ARM assigned all of its contractual rights to during the time period when ARM alleges Medallion breached, won't produce certain documents that we've asked for. Now, we've asked for Glencore's terminal services contracts at the Port of Corpus Christi. We've also asked for the nominations under those contracts. In other words, the document showing whether those contracts were used during the 1-year period when Glencore was performing. And the documents are directly relevant for at least 2 reasons. One, for showing how ARM has overstated its damages, and 2, for proving Medallion's failure to mitigate defense. Now, we don't agree with ARM's damages model, but if it applies, Glencore's contracts will show that ARM, through its relationship with Glencore, had different options for crude oil export that it claims it lost out on. And Glencore's agreements here are relevant because it was Glencore that was performing the contracts with Medallion. And the nominations under those contracts will show whether ARM or Glencore attempted to use those contracts. In other words, whether they attempted to mitigate the damages or not. ARM and Glencore both had a contractual duty to mitigate. They were working together on this deal. Now, Glencore's principal objection here that the documents are proprietary or confidential, it ignores the express contract language of our protective order. We have a protective order. It applies to documents produced by non-parties like Glencore. And Glencore can designate documents attorney's eyes only, and the order prevents the documents from being used for any business or competitive purpose. And Your Honor, there's some detail in the background on this case that really helps to show the document's relevance. And we have some visuals to show you. If you are able to allow screen sharing, I can show those. It looks like it's disabled right now.
Go ahead.
Sure. So, Your Honor, the case arises out of a set of contracts between Medallion and ARM, but there's 2 other companies that are involved here. That's Epic and Glencore. Now, Epic, as you can see on your screen, operates a pipeline that carries oil from West Texas near Midland down to Corpus Christi, where Epic owns and operates a terminal. Now, in April of 2019, Medallion entered into contracts with Epic, giving Medallion capacity on Epic's pipeline, as well as the right to nominate a tanker vessel for loading crude once a month at an Epic terminal in Corpus Christi. And the plaintiff in this case, ARM, markets crude oil. So in July of 2019, ARM entered into 2 5-year contracts with Medallion, in which ARM agreed to make fixed monthly payments to Medallion in exchange for receiving that capacity that Medallion had on Epic's pipeline and terminal. Now, ARM's goal with this was to offer export opportunities for its customers. But the problem is that ARM didn't have any experience or ability to actually export crude oil. So it needed another company in the export business. That's Glencore's role. Glencore was brought on to manage the challenges associated with receiving oil in Corpus Christi, loading it onto tankers, and shipping it for sale to international markets. So to accomplish this, ARM in December of 2019 assigned all of its rights and obligations under those agreements with Medallion to Glencore. Now, then under an agreement that Medallion's not a party to, but that ARM is now trying to claim damages under, ARM agreed to supply crude oil, and Glencore agreed to make all arrangements for exporting the crude oil out of Corpus Christi. And Glencore and ARM agreed to share the profits, with Glencore receiving 60% of the profits. And Your Honor, I need to take a moment to discuss the connection that Glencore has to this case if it's not already apparent. Glencore is not some uninterested third party. The relationship between ARM and Glencore was that they were in this together. I mean, ARM certainly seems to think that that was the case. Let me show you a page from ARM's second amended petition. ARM uses this term ARM/Glencore to refer to the two of them together. That term, ARM/Glencore, it appears in the second amended petition 26 times. And why do they do this? It's because ARM is trying to claim damages. They want all of the damages that if they exist, they accrued during the time when Glencore had all the rights under the agreements, and they belong to Glencore. So ARM assigned its rights to Glencore in December of 2019, and service on the EPIC pipeline was scheduled to begin in April of 2020. We know what happened. COVID hit, and along with a Russian-Saudi price war and an oversupply of pipeline capacity, the price of oil plummeted and the price of transport capacity plummeted. And ARM and Glencore were stuck with these contracts negotiated at rates in 2019 that were now far above market prices. So the documents that have been produced in discovery show that ARM and Glencore set out to manufacture a pretext to get out of these contracts. On October 5th, 2020, ARM and Glencore sent a letter to Medallion. And you can see Glencore's logo up here in the top left of this letter. Now, you probably remember this letter. This was the subject of all the hearings that we were here in front of you about a year ago. The issue that you heard a lot about was whether that letter sent by ARM and Glencore was a notice of default. And you found that it wasn't. After October 5th, Medallion asked Glencore for documents supporting the issues in that letter. And Glencore kept telling Medallion it would provide documents, but it didn't. The bottom line with this is that Glencore is not some uninvolved third party being dragged into this. Glencore is central to this dispute. So finally, in March of 2021, ARM and Glencore terminated those assignments, and that left ARM in default to Medallion. And as you remember, that's when ARM filed this lawsuit. So since then, ARM amended its petition to add other claims, including breach of contract and fraud claims, and it served an expert report in which it calculated over $100 million of damages. Now, it's ARM's damages allegations put Glencore even more into the middle of this case. And that's because ARM is seeking 100% of damages under a contract that Medallion was not a party to. And even though 60% of those damages would belong to Glencore. And ARM's alleged damages put ARM and Glencore's export arrangement squarely at issue. That's where the documents we requested from Glencore, and those are the terminal contracts at Corpus Christi and nominations, that's where they come into play to show overstated damages by ARM and that ARM failed to mitigate. So as for overstated damages, it's ARM's expert opined that ARM would have profited if it had an array of options every month to ship the most profitable grade of crude oil to whatever location in Asia or Europe that would bring the most profits every month. And according to ARM, the alleged problems with the EPIC terminal capacity hindered those export options. That's why we need Glencore's contracts with other terminals in Corpus Christi. Glencore was the party performing, and it was the party that was exclusively responsible for actually exporting and selling the oil. So depending on what other terminal agreements Glencore had in Corpus, ARM might not have lost much, if any, options for exporting, because Glencore, again, the party that was actually exporting, could have done it through a different terminal at Corpus and still share the profits with ARM. Now, the second main reason, the failure to mitigate, if you look at the Terminal Services Agreement, section 13.5, which I've put up on the screen here, it requires a non-defaulting party to use commercially reasonable efforts to mitigate its alleged damages. When Glencore was the assignee under this contract, Glencore had that same contractual duty to use commercially reasonable efforts to mitigate. So Medallion has alleged that ARM failed to mitigate its damages. It's an affirmative defense. That means the burden is on Medallion to prove the amount by which ARM's damages were increased by its failure to mitigate. And we need the documents to do that. We need Glencore's other terminal contracts at Corpus Christi to show what options Glencore had for other terminals in Corpus Christi and what they would have cost. There are we think at least 8 other terminals that could accommodate a partially loaded larger tanker vessel. And if Glencore had access to those as options.
Lawyers arguing.
Someone's sound is on. It might be Chad Cross. Maybe is he on this case? I'm going to go ahead and mute him. Who is Chad Cross?
I'll keep going. If Glencore had these other terminal options, the question of whether it would have been commercially reasonable for them to at least try to access them for export is certainly relevant to the damages and the nominations under those contracts, again, meaning.
All right, I get it. Let me hear the response.
Sure, thank you.
Your Honor, good afternoon. My name is Peter Bemke. I'm a lawyer for Glencore. So I think just briefly on background, I'm not going to get into the merits of the case, or we're really not. We are a third party, and we're not interested in the merits of the case at all. Glencore has been fully cooperative with Medallion's discovery requests as they relate to Glencore's assignment and the contracts and its performance of those contracts with Medallion and its relationship with ARM. There was a first subpoena that was issued by Medallion to Glencore over a year ago. Since that time, Glencore, we have the details in our brief, but essentially we've expended at least $150,000, maybe $200,000 in collecting, reviewing, producing documents. We have been fully cooperative in that regard. The line that we have drawn is Medallion is now seeking documents and information concerning Glencore's business and relationships with third parties that are not relevant to its performance of this contract or its relationship with ARM. And I just want to be very clear about that because from the description from Medallion's counsel, there's this sort of suggestion, and actually they say the word in their brief, that ARM and Glencore were partners generally, or that there was an implication that there was some broader profit sharing agreement across their businesses. It's just not the case. Glencore is a separate company, an independent company, and one of the largest commodity trading companies in the world. Its only relationship to this case and to ARM are the contracts that govern that relationship during the period of the assignment. And ultimately, this is, the question comes down to, it's not whether this information is a trade secret or commercially sensitive. It is, certainly, and we've explained that in our papers. But that's by way of background to explain why we're drawing the line.
They've said that there's a protective order in place that should deal with those issues, or is the protective order not sufficient to deal with those issues?
It is not sufficient from our standpoint, Judge. For a couple of reasons. I mean, this information that they're requesting go to customer identification, pricing, trading strategies, shipping availability. This is, we say it in our brief, but this really is the lifeblood for trading companies such as Glencore. It's an imperfect analogy, but it's it's like the formula for Coke. And
so I think you understand what kind of the issue is from the standpoint of plaintiff in this case, that they need to figure out the issues involving mitigation. And I agree with you. They probably don't need to know all of the information that they're requesting, but surely some of the information could be produced and protected by a protective order, and still allow them to get the information that they need. But I am sympathetic to the notion that you don't want to give away the secret sauce, so to speak. And so what can we do to alleviate your concerns, but still try to solve the issue or deal with the issue the plaintiff is concerned about?
Yeah, I appreciate that, Your Honor. I mean, the concerns that I have, I'm not sure if they can be dealt with a protective order. I mean, number one, this is information that if it were to be produced, presumably would be handed over to Medallion's consultants and their experts, who are, I have to assume, are people who are, in the industry.
Right.
Now they have Glencore's trade strategies and very proprietary information in front of them. And although I have no doubt, that they would do everything they can to comply with the protective order, it's also the case that once this litigation is finished, their minds are not going to be, wiped clean of that information. They have it now. It's out there.
Sure.
So that's concern number one. And concern number two is if this information, I mean, again, I don't think it's relevant, and I would like a minute to explain that. But if this information were to find its way into summary judgment briefing, or Medallion would seek to use it at trial, my understanding of the way that Texas works in terms of keeping information under seal is that it's a very high burden to do that, and there is a substantial likelihood that this information can end up becoming public in that context. And we're not a party. I'm not going to be sitting in the courtroom there to object, over the use of information or whether something is confidential, proprietary or not. Essentially, once it's out of the gate, once it leaves Glencore, we have lost a large degree of control over that information. And so that is the concern that's driving this. Although I would say,
I think is it all of those are justifiable concerns. I don't necessarily agree that there's no way to deal with this. I think there's always a way to solve these issues if we just kind of put our mind to it. So what is it that Mr. Downs, what is it that you really need? Like, I don't know why you would need client lists and pricing strategies for Glencore. So what is it that you really need to deal with this mitigation issue?
That's right. I don't think we need client lists or pricing strategies, and we haven't asked for those. We've asked just for the contracts themselves, just for the nominations themselves. So we need to know, we need the contracts. We need to know what terminals they had access to, what kind of vessels, what size vessels they could bring into those contracts, loading rates. We just need the contracts themselves. We're not asking for.
Well, isn't that have all the information that he's concerned about producing? You said you don't want the information, but it's all going to be in those contracts, right?
Well, some of it may be in there, but Your Honor, first of all, the protective order says it's got a provision that says that none of this can be used for any commercial, business, competitive purpose of any kind. And like you said, there is a way to deal with this by sealing proceedings. It's not guaranteed this is all coming out into the public record, but the information that we need is what terminals they had access to, what kind of vessels they could bring into those terminals, and we just need the nominations to know whether those services were actually used during this narrow 1-year period.
Mr. Bemke, is there a way that you could produce just those 3 items of information under a protective order and not have to produce the contracts?
Your Honor, I can't answer that right now. If I understand what Mr. Downs is saying, is they want information concerning the volumes that were shipped and when they were shipped.
No, say it again, Mr. Downs. You had 3 things.
Right. We need to know the terminals that they had access to.
Terminals they had access to during that time period.
During that time period. The kind of vessels, the size of vessels or class of vessels that they could bring in and out of those terminals. For example, if the terminal was capable of handling a certain kind of vessel, but Glencore didn't have that kind of loading window at the terminal, we'd need to know that. And
Wait,
one
say,
thing,
say that next thing again. They didn't have the what?
a loading window, for example, the contractual language saying what kind of vessel they can bring in and out of that terminal.
Okay.
And we would need to know for purposes of mitigation what it would have cost them to use those terminal services. And that's the information from the contracts. From the nominations, we would need to know whether they used those services. In other words, whether they nominated vessels and the volumes.
So, Mr. Benke, my thought is that we could handle this one of two ways. We could just order you guys to produce all the contracts, which I don't think is the ideal way to do this. Or we could have you enter into a stipulation with Mr. Downs that in the alternative that you produce these 3 items of information during the pendency, during that 1 year period, or approximately 1 year period, under the protective order. What would you prefer?
Your Honor, I think we would prefer the latter choice.
Mr. Downs, does that work for you?
I think that should work for us. Thank you, Your Honor.
Why don't you guys work on putting together a written stipulation on this? That's the only issue we're dealing with today, right?
Actually, Your Honor, there is one more issue related to depositions. I believe Mr. Carter will tell you a little bit about that.
So let's first off, that for this issue, I want you guys to put together a written stipulation. For some reason that you break down on the wording and you need my intervention, how long do you think it would take you to come up with something that we can enter into the record? Could you do that in 10 minutes, or would you need a couple days?
I think a couple of days, Your Honor. I mean, for my part, I need to consult with my client and figure out exactly where to find this information and make sure that that we can produce it in the way that I think we're contemplating now.
A couple of days should work for us, but there has been a little bit of a history of delay here, so we'd like to make sure it gets done quickly.
Okay. So what would be the best way to do this then? My one option would be to you guys could come back on either next Monday over Zoom. I don't know if you guys are all local, or you could come in person. My Friday hearing docket is in person. My Monday docket's on Zoom. We could give you a time slot next Monday or this Friday where you could come back if there was an issue with the stipulation. What would you prefer?
Your Honor, I'm based in New York, so if we could do a virtual hearing, hopefully it won't be
Monday.
necessary, but if it is, that would be my preference.
Monday work for you, Mr. Downs?
Yes, that should work.
And we may not need to, it's just if you can't work out an agreement. So Rhonda, if you're there.
Your Honor, I'm sorry, one point I would add, on Monday, I'm in a federal court mediation with Judge Nowak up in Sherman all day.
Well, you'll have to take a break if you need to be here for it.
We should be able to arrange that. I just wanted you to be aware.
Okay. I don't anticipate you'll need a hearing, but I just want to be able to give you that option in case you do. So let's go ahead and set this just in case. We'll set it for next Monday. What time is your mediation, Mr. Bailey?
It starts at 10 in the morning, goes till 5.
I could set it at 9:30 if you'd prefer. Is it in person or remote?
In person.
Okay. When would you like to do the hearing, Mr. Bailey?
If we pushed it after Monday, that would be best. If you need it Monday, then if you set a time, I know Judge Nowak will work around it.
Let's just set it for 3 o'clock next week. And if, again, please cancel if it turns out you don't need it. It's only there if you need it. All right, the issue on the deposition, what's remaining on that?
Your Honor, this may just be a preview, which is that we have been, just so for completeness, we have had a little bit of an issue on getting deposition dates out of Glencore for the depositions of the 2 principal Glencore employees, Guy Freshwater and Aaron Dunn, who were involved in this deal. And we've been asking for quite some time and yet have yet to get dates. And we're just concerned that we not let much more time pass because, we've
Well,
got
why don't we do this then? Why don't we have, Mr. Bemke, do you have any dates right now for that?
I do not, Your Honor.
So if you don't,
The delay has been due to issues with coordination. But in any event, we're continuing to meet and confer on those issues. We haven't received a deposition notice or subpoena of any kind. I think we're still at early stages in terms of teeing this up as an issue for the court.
I don't know if this would work, but we could also just have that discussed next Monday at 3 as well. If you guys can't come up with an agreement, then I could just order a date then, but give you until now and then. Does that work for you, Mr. Carter?
Yes, it does, Your Honor.
Mr. Bemke, does that give you enough time?
I will do my best, Your Honor.
I'm not saying the depositions have to occur by next Monday. You just have to get.
No.
Monday.
Yes, I understood, Your Honor. We're dealing with people with travel schedules, and of course, the depositions have to take place in New York, and there are different issues to coordinate.
We want to work
We'll do
with
what we
them,
can.
but they do. If they're going to do business in Texas, they have to follow our rules too. So you just need to make sure that they get us some dates by next Monday. Okay.
Understood, Your Honor. Thank you.
And the way I do this is you have to provide at least 3 dates during the week. And then, Mr. Carter, you're going to have to pick one of those dates.
Thank you, Your Honor.
And let's say within the next 3 dates, within the next 6 weeks, or I don't know how quickly you need the depositions.
That would be great, Your Honor. Yes.
3 dates within the next 6 weeks. All right. Anything else, guys?
I don't think so. Thank you. Thank you for your time, Your Honor.
No
Not for
problem.
much, Judge.
You guys be safe, and hopefully we won't see you next Monday, but if we need to, we'll see you next Monday.
Thank you very much.
Thank you.
All right. You guys be safe. Is everyone here on the Lester D. Allen versus CLC roofing case?
Judge, I'm here for the defendant. We're the movement today.
Okay.
Hunter Cox here for plaintiffs, Your Honor.
All righty. Is there a Chad Cross on this as well?
Yeah, that's the corporate representative of CLC Roofing.
Okay.
He was on it. I don't know if there he is.
And then the attorney on the other side is Hunter Cox. Is that right?
Yes, sir.
Yes, Your Honor.
Okay. Do I have the right folks spotlighted?
Yes, sir.
Yes, Your Honor.
All right. I've read everything. Why don't you guys go ahead and proceed?
Judge, just and if you've read it, I'm not going to belabor the point. I started off and their response points that out, that I added a lot of stuff in the first part of it, but we really ended up focusing on two issues related to the commission situation and putting the equitable claims aside because that became hazy and murky with their response and their subsequent pleading amendment. But I was very careful in drafting this motion in terms of the evidence I'm relying upon, which is all the plaintiff's testimony. I did not rely on anything from CLC to prove issues that we have asserted. The motion sets forth testimony of Mr. Allen that this new alleged agreement, and as the court's well aware, any agreement has to stand on its own feet. It has to have all the components, one of which is
The oral modification is what you're talking about?
Yes, sir. The oral agreement to lift the cap on the commission schedule that was in writing.
Mr. Cross, there was one thing I think I may have missed, and I want to make sure I'm kind of following.
Right.
There was a
Okay.
cap for $5,000,
Yes, sir.
and then they paid a $50,000 bonus.
That is correct.
But you guys are saying there was no elimination of the cap, but it would seem like if they paid $50,000, that would be above the previous cap, or am I missing something there?
From time to time, the payments would exceed the cap, but that was gratuitous. It wasn't required. And it was pointed out, especially in the meeting that they had when Mr. Allen presented the invoice for $330,000 for the Ford Commission. He testified that he was told that was not their agreement. That was, above the cap. We're going to stick to the agreement. And this was all he was going to get, was $50,000.
It seemed like this is a little loosey-goosey then.
I wouldn't say so, sir.
Okay.
And in what way can I help you with that, being loosey-goosey?
I just think, if the cap is 5,000 and they go back and pay them 50, it just seems like this is a fact issue on what what was the agreement, because obviously they didn't strictly adhere to the cap, and so sometimes they paid more and sometimes they didn't. And there's
Regardless of that element, Judge, there still has to be consideration for an agreement to be enforceable, and there is none. And Mr. Allen testified that he offered nothing. And in their response, their only response to that issue is that, well, he was performing additional issues, performing a different tasks at the time. And as we pointed out in our motion, that's just insufficient. It has to be a contemporaneous consideration given with the new agreement for it to be enforceable. And they've offered absolutely no case law that contradicts that in any way whatsoever. And I personally think the consideration issue is really the stronger issue. But if Your Honor considers this to be loosey-goosey, then you can go straight to the accord and satisfaction defense, which clearly shows that there was an intent to resolve whatever was owed on that commission by the issuance and acceptance of a check based upon the meeting they had when the original invoice for $330,000 was submitted. And there is case law that says that, there has to be an intent, as you know, to resolve a disputed issue. But that intent can be shown by circumstantial evidence. And the fact that they had this discussion, they had a disagreement, he was told, this is all you're going to get, period. And he accepted the check, cashed it immediately, and continued to work for 5 months. I think that too shows that accord and satisfaction is a defense to this claim for this additional compensation for the Ford storage job. And again, they've showed nothing that disputes any of that or creates a fact issue, because we didn't create one by adding any evidence that would cause a fact issue dispute, even with regard to the consideration or the accord and satisfaction. And the equitable claims, Judge, I don't know how you want to deal with that, but I mean, those are pretty clear cut, and they obviously dismissed their equitable claims.
I thought they dismissed those. I just assumed those were.
They added another one along the same lines of quantum merit, and it's the law's the same. So
The way I typically handle that is if there's a new claim that's brought after, I think I have to kind of handle this way. If there's a new claim brought after the summary judgment, then you would need to file a new summary judgment on it. I don't know.
I necessarily agree with that. But I did point out in my motion that, if they've already agreed with me on that, with the equitable claims, filing a new equitable claim, that's just creating more work. It's not, and that attorney's fee should be awarded if I have to file another motion for summary judgment to knock it out.
Mr. Cox, response?
Regarding the quantum merit claim, Your Honor, we've had a quantum merit claim on file since our original petition. He didn't move on it. We didn't add a quantum merit claim. Just on that issue, since we say it's been on file since May 18th of 2021, it's in our original petition. It spells out in our causes of action section. Regarding the lack of consideration argument also, Your Honor, we object to that, and we especially accept because defendant has not pled no consideration as an affirmative defense and has not made a verified pleading either. So under Rule 93, he has to have a verified pleading regarding no consideration or failure of consideration or lack of consideration, and he hasn't done that.
Mr. Cross, was there a verified pleading on this?
I think there's a verified pleading that talks to the fact that they're not liable in the capacity in which they're sued. I can't remember what all there is in that.
I'm pretty sure Rule 93 requires that lacking consideration has to be specially pled, but
And I have it in front of me, Your Honor, if it does say
I
that.
don't have the rule in front of me,
so,
but I can get it.
And while I'll wait for him, sorry.
okay, I'm looking here. It's 93. What subsection is consideration? I don't see that lack of consideration is. Let me see.
Number 9, Your Honor.
What, 9?
Number 9 in Rule 93.
Yeah, it's number 9.
Yeah, you're right. That a written instrument upon which a pleading is founded is without consideration.
That's not what we're alleging.
Yeah, that this is not a written instrument, correct?
That's correct. We're saying that the oral agreement,
Is
that
without-
they're founding, that's the basis of their claim for damages.
And either way, Your Honor, we also are prepared to argue that there was consideration.
Okay, go ahead and argue it.
My interpretation is it had to be pled. So, Your Honor, in this case, my client had a written agreement that set out what his duties and obligations were. It's undisputed by the parties that from the date he signed that up until the oral modification, that the defendants expanded and exceeded the scope of those original obligations and duties. That's not in dispute. That's been testified to by the corporate representative, Mr. Cross. And what we've argued is my client took on this additional responsibilities that was extra contractual. He went to the owner, said, hey, I'm going to provide these extra contractual services. We've got to remove the cap on commercial compensation. And the evidence shows they did. The 50,000 plus, there's other evidence that shows not just one time, there were multiple payments in excess of the cap. And what they were bargaining for is the continued future performance of those extra contractual responsibilities. My client had no obligation to perform those under the written agreement. He was taking on new work, and in order to continue to perform, he put that in it's in his affidavit that's in evidence, he would not have performed those extra contractual duties had they not agreed to remove the cap. And that was consideration, Your Honor. There were future promises for future performance. So we think that's without merit to say there was not consideration for the oral modification. We think there's plenty of evidence to support that there was, because he had no obligation to perform that. And the cases cited by counsel say that, hey, you can't have, it's not, I'll pull the case, Your Honor. It says, stating that agreeing to do what is already required does not constitute new consideration. It's not disputed that his written agreement, no one's claiming that he was required to perform these additional tasks in his original agreement. This was extra stuff that was not contemplated, and the defendant's corporate rep has admitted that. And further, and so, Your Honor, we think the lack of consideration argument is, there's plenty of fact issues in this case. And additionally, in accord and satisfaction, Your Honor, as counsel noted, and the standard for that is that for accord and satisfaction to prevail, there must be evidence of a dispute between the parties, and they specifically and intentionally agreed to discharge the party's obligation. Your Honor, we've submitted evidence that my client never intended to discharge them of any responsibility. That's in evidence. There was no release. He sent them an invoice for the full amount, and it's been disputed this whole time. My client never agreed, and there's no evidence of that. And if there is, at the bare minimum, there's a fact issue as towards the intent of the parties in regard to accord and satisfaction that precludes summary judgment. Furthermore, we've submitted evidence that shows it was not uncommon for the defendants to pay my client in multiple installments on commissions. That's in evidence, and that's happened in the past, and there's evidence of that they've done partial payments. In those instances, it wasn't accord and satisfaction. It's the same thing here. And my client, there is simply no evidence of intent to discharge defendants from any obligations regarding his full commission. Your Honor, we think the motion for summary judgment should be denied.
Briefly responding, Judge, the case that he cited on the accord and satisfaction, on consideration, specifically says it has to be something. In our reply, there is a case that also says that it has to be a promise at the time, and it has to be new, it has to be contemporaneous. Also, we cited Lester Allen's testimony, Exhibit 5, to our motion, page 84, line 7 through 25, who said he offered nothing new in consideration for this new agreement. I mean, we're not arguing that we don't believe the agreement took place, but be that as it may, that we didn't want to get into a fact issue on that. We're just taking on this one element that specifically says he has to just continue to do what you're doing is not new consideration. For whatever reason you decided to do it, you did it. That doesn't give you new consideration. Whether that they paid over the cap or under the cap or something else on some other cap has nothing to do with whether this contract is enforceable. Each contract has to stand on its own. They've pled nothing of that in their pleadings. And they can't get around the fact that their own client testified, I offered nothing new for this agreement. I just wanted to be paid more money. That's exactly what he said. And with the accord of satisfaction, the case that we cited, it's not necessary that the plaintiff in this case say, I agree to discharge this debt or sign a release. That can be shown by circumstantial evidence. And it's undisputed that he presented the $300,000 invoice. He was told no. This is out of his testimony. He was given a $50,000 check. He took it, cashed it, and continued to work for 5 months. That is undisputed. So with all due respect, I think the accord of satisfaction is as healthy as the consideration argument.
All right, the court is going to deny the summary judgment as to the breach of contract. It's going to grant it as to the claims for equitable relief, with the exception of the quantum merit claim. All right, guys, thank you so much. And you guys be safe. You have a good day, okay?
Thank you.
Thank you, guys. Okay. So let me turn off YouTube.